Morning, Judge.
Good morning, Esme.
Good morning, Judge.
Oh, hold on, I can't hear.
Okay,
Can you hear me?
I got YouTube on you also. We have some non-party public in the waiting room, so I'm sending this message. Well, let's see. I saw a lot of people in the waiting room, but I don't know
Just so
what.
you know, Mr. Carejo is not a party.
Yes, I know.
Okay.
Yes, that's why I put it.
Good. Can you hear me?
Message. Yeah.
Yes. Morning, Erica.
Let's see. Well, everybody was on there, and then they just left. They're long gone. I don't know if they after I.
You put the message.
Yeah, but I put it for non-parties in public.
Maybe they were all non-public.
I don't get it.
Oh, no, I think Miss Melton is signed back on and Miss Abby Lane. We're just missing.
Yeah, I don't know why they got off, but anyway. Yeah, if they get back on, that's good.
What does this mean? The characterization of amicus fees.
I think that the amicus wants to collect the fees she's owed, and she wants a withholding order, and so I need to see what that's about. I need to. I don't have that motion here before me. I don't have my computer, my county computer, that is, and so I can't look up the motion itself. Can you email that to me, please?
Yes, Judge, I'm doing it right now.
Well, I don't understand what happened to everybody. They cannot log them back on. And I realized that I cannot get on YouTube unless I'm the host. So I reclaimed it.
Okay, yeah, Judge, I'm co-host.
Yeah. Well, it says you're the host too. You're the co-host? Okay. Yeah. Bless you.
Thank
Did you
you, Judge.
sneeze?
Yes, thank you. I woke up with allergies. Thank you.
You want to give them Miss Lane a call, Miss Lane, and see what happened. They were on and then they were off.
Yes, Judge, I'm calling right now.
Hmm. Hmm. He's not logged in. Jackie, I don't see her on the list of
Jackie,
participants.
Judge, I see Ms. Lane. I know I just got off with Ms. Carrion's law office. She's logging in because she's the amicus.
Yeah, but
Um,
why
but I
don't I
just
see him on mine?
I do see Attorney Abby Lane.
Okay, once Abby Lane is on there and Lisa Hayes and Carrion and Mr. Chavez, would
Let
you
them
let
in?
them in? Because I don't know why I don't see him on mine.
Okay, all right. And then it says that I'm co-host, but okay, I'll let them in because they're already in. Okay.
Okay.
Good morning.
Morning. Good morning, everyone.
Good morning, Judge.
Good morning.
All right. Erica, we'll go ahead and get on the record in cause number 2018 DCM 1766 in the matter of the marriage or in the interest of the child, VCEC, just the initials, to hear certain matters and then to set this for trial if y'all haven't announced it, it's settled. And anyway, you were supposed to go to mediation. I think you did, but I don't know what happened. And you will tell. So if I can hear announcements, please, on the record.
Lisa Hayes for Denise Alvarez. We're ready, Your Honor.
Abby Lane represented Gabriel Chavez. Ready, Your Honor.
Ms. Carrion, you're on mute.
Yes, thank you. Good morning, Your Honor. Angelica Carrion Beltran as amicus for the children.
All right. And this matter is being conducted by remote, by Zoom. It is being streamed on YouTube in case any the public or non-participants, non-parties want to observe. Anyway, okay. Tell me, the last thing I knew that there was a mediation take place. What was the result of that?
Your Honor, we were partially successful, so there is a partial MSA.
Judge, can I address that as well?
Sure. Yeah, so
Yes, sorry. So we did reach an agreement on conservatorship, possession, and access for these two children. Mr. Gabriel will be appointed as sole managing of Ethan, and Miss Denise will be sole managing of Valerie. And so the issues that are outstanding are the child support amounts and any arrearages that have been owed or may be owed from the past. And then the amicus fees is another issue, and the attorney's fees. And so what I wanted to ask Your Honor today is if we could have an entry of judgment to enter an interlocutory order on the issues that were resolved. I have tried to settle those issues, the remaining issues. Unfortunately, we haven't been able to do that. So after the interlocutory order is issued, I would like to withdraw, and that's the reason I'm asking for an entry of judgment so that I can at least wrap up that portion of the case for Mr. Chavez before I get out of the case.
all right. Okay, so I understand there has been a partial agreement on conservatorship that the two children separately, each party will be named sole managing conservator, Mr. Chavez of the young man and of the female child and Miss Melton. And then the only issue is the child support, arrearages, the amicus attorneys, the amicus fees, the attorney's fees, and the amount, if any, that are owed. Is that correct?
That's correct,
All
Your
right,
Honor.
and then you're asking that temporary orders be entered in that regard on the MSA, on the matters that have been agreed to.
Yeah, so we're asking for, final interlocutory order just on those issues. And
Okay,
then leave the rest of it open for that
And
to
then-
be resolved.
and then Ms. Lane intends to request a removal or withdrawal, excuse me, withdrawal as attorney.
Yes, with the agreement of my client, he's in, with that understanding, he's in agreement.
And that's what I was going to ask him. Mr. Chavez, just on the issue of, and I'll ask you in a minute, I'm going to ask that the terms of the agreement be stated on the record and acknowledged by everybody. Generally, you've stated it. Mr. Chavez, on the withdrawal of your attorney after the entry of a temporary orders or interlocutory orders, will you have an objection if she withdraw? I don't have any motion with me right now, but nevertheless,
Correct. Yeah, yes, Your Honor.
you will object?
Oh, no, I would not object. I'm sorry.
Okay. All right. Then in the event you file a motion to withdraw, give the appropriate notice. And then we will take that up if you submit to the court an order of withdrawal signed by Mr. Chavez, acknowledged in some way, then none of the attorneys have any problem with the withdrawal, do you?
No, Your Honor.
The other attorneys? Yes, okay. All right. Okay, and so how long will it take to prepare that order?
Can have it ready in 2 weeks by the 20th, actually next week.
All right. And could I have, please, on the record, the terms of the agreed portions of the MSA, please? If who would want to recite that for the record?
I have
You
it queued
already-
up, Your Honor, so I can recite it.
All right, go ahead.
And Your Honor, just for the court's information, this was filed by the mediator on April the 14th of 2025. Mr. Simcoe was our mediator. The
Okay.
parties have entered into a partial parenting plan. With respect to conservatorship, Ms. Alvarez is going to be the sole managing conservator of Valerie with all the exclusive rights and duties of a sole managing conservator, inclusive of passport application and possession of that passport. Mr. Chavez is going to be the possessory conservator of the child Valerie. Mr. Chavez is going to be the sole managing conservator of the child Ethan with all the exclusive rights and duties of a sole managing conservator, inclusive of passport application and possession of that passport. Ms. Alvarez is going to be the possessory conservator of Ethan. There will be a residency restriction to El Paso County for both children. Ms. Alvarez is going to have possession and access of the child Ethan as agreed upon by Ms. Alvarez and the child. And Mr. Chavez will have all other possession and access of Ethan. Mr. Chavez is going to have possession and access of the child Valerie as agreed upon by Mr. Chavez and the child. And Ms. Alvarez is going to have all other possession and access of Valerie. In addition, the parties have agreed that there will be the mutual Big Four injunctions, and also that neither party may contact the employer of the other party or allow any person to do so. The parties are going to utilize AppClose for all communications regarding the children, and commencing with the 2024 tax year, each parent will have the federal and state tax dependent exemption for the child in their possession. If I may call my client to confirm her agreement.
Okay, let me go and get both the parties sworn in. Mr. Chavez, Ms. Milton, would you raise your right hand to be sworn, please? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Milton?
I do.
And Mr. Chavez?
I do.
Very well. You may proceed.
Thank you. Ms. Alvarez, you've heard me recite the agreement today, correct?
Yes, ma'am.
And that is the partial mediated settlement agreement that you entered into in April, correct?
Correct.
And you agreed that the court enter a judgment on those terms as required by the code.
Yes, ma'am.
Your Honor, I'll pass the witness.
No questions, Your Honor.
All right, Ms. Carrion.
No questions, Your Honor.
Okay. All right. Ms. Lane, do you have any questions you want to ask Mr. Chavez?
Yes, I'd like to call Mr. Chavez.
All right, he's under oath.
Mr. Chavez, can you please state your name for the record?
Gabriel Chavez?
And you heard the agreement, the terms of the mediated settlement agreement that were read onto the record by Ms. Hayes?
Yes.
Does that accurately reflect the agreement that we entered into back in April?
Yes.
And you're asking that the court enter that as a final order?
Correct. Yes.
Believe that that's in the children's best interest?
Yes.
That's all I have, Judge.
Very well. Okay, how long will it take? Who's going to draft that interlocutory or temporary order?
I'll draft that, Your Honor. I can have it ready by Friday, next Friday, the 20th.
Next Friday?
Yes, Your Honor.
That'll give you enough time to circulate it for approval? Is the
Um,
form?
Well, actually, I can circulate it probably Monday for everybody. I don't know if that gives everyone enough time. We could, yes.
I'll review it as soon as I get it.
All right. Okay, next Friday, then we'll set as an entry of judgment by submission only on the interlocutory order.
That'll be
Alright.
June 20th at 4 p.m., Judge.
June 20th at 4.
Mhm.
All right. Now the other issues, we got some remaining issues that were not settled, and that have to do mainly with child support and the amicus fees and any attorney's fees.
And Your Honor, my motion for the characterization of amicus fees is set for today as well.
I did not get notice that that was set today. I just got notice that it was a review hearing.
Yeah, I'd rather hear it all at the same time.
Pardon me?
I think I'd prefer to hear everything at the same time because I need some briefing and law on what you're asking the court to do.
And I provided that in my motion, Your Honor.
And
I'm
Mr.
sorry.
Travis will have a response as well, so we'd like time to do that.
Your Honor, it was served May 8th, and it was set today as part of the motions hearing. So I'm prepared to proceed today. There's been no response, but there's been
All right.
time
I'll
for
hear you. I'll probably defer it and do my own research on it because it's the first time I've had this issue come up in this manner from an amicus. So I'll hear your argument. I will give time for counsel to give a response, but and I'll probably defer my decision. But you may proceed on that.
Thank you, Your Honor. With regard to the amicus fees, and just to give the court a timeline, in November 15th, 2022, both parties were ordered to deposit an initial fee to the amicus, and both did that on $1,500. On December 15th, 2022, there was an additional court order that required both parties to submit $500 a month and a like payment on the first day of each month thereafter until further ordered by the court. A copy of the order for the deposit of those additional fees was attached to my motion. There was a compliance report filed with the court in December 19th, 2022. The court was advised of the lack of compliance dating back to that date in 2022 by Gabriel Chavez, and was advised of the numerous subsequent violations of the court order. As the court order was written, Gabriel Chavez is now in arrears in the amount of $16,000 dating through May 2025. Your Honor, we are asking that this court has continuing jurisdiction over those issues. I'm seeking to have the amicus fees characterized as necessaries for the benefit of the children and to characterize them as additional child support under Family Code Section 157.067. In that regard, I'm also seeking a issuance of withholding order for the additional amicus fees from Gabriel Chavez as he has failed to comply with these orders dating back to November 15th, 2022. Since the time that the dispute was raised with Ms. Lane, she has asked that I provide all my invoicing to her, and I have done that. She has expressed a willingness to assist with resolving this matter, and in essence, it resulted in no meeting of the minds as to how to resolve this issue. Ms. Lane has involved herself in this dispute, and so I'm asking that she continue to assist in this matter in responding to the motion. As the court has indicated, he's going to allow the respondent to do.
Okay. On the characterization as necessary and as additional child support, do you have, other than the provision of the family code you cited, do you have any case law that would allow the amicus to characterize it in that manner and consider it as child support?
I do have research on that issue, so let me pull it up here very quickly. Research. One moment, Your Honor. Let me find that. Not immediately finding it, Your Honor. I believe there is case law on point, and I can submit those to all parties
Yeah,
involved.
just submit it in a letter brief to supplement what you're orally stating here today in support of your motion.
Yes.
In any way, Ms. Lane, do you have any response at this time, or do you want time to do that?
Yes, I'll just briefly provide a response, and then if we could have the same opportunity to provide just a brief letter to Your Honor regarding this issue. But Mr. Chavez's position is that those amicus fees have not been reclassified by the court as child support. And so as such, they don't qualify under that family code that was cited by the amicus. And so basically his argument is that no benefit was provided to the child due to lack of involvement with the child and interviewing the child and being involved in the case, and other than, attending hearings. And so that's his position. And so because of that, his argument is that it can't be reclassified as a need to the child because the services were not provided in the best interest of the child. So that's his argument as to why they shouldn't be reclassified as child support and garnished in the same way.
And Your
But
Honor,
we will-
as a response, all my billing was provided to Mr. Chavez because he was mistaken in his understanding. So the billing was all provided so he could see the progression of my involvement with the case. And then to remind the court, he refused to allow me to visit with the child or to do a home visit, and has not, despite representations that issue would be addressed and resolved, there has been no resolution to that issue. Now that the mediation has occurred, I don't believe that issue is relevant any longer, but I was at his home, I was ringing the door, I was calling him, and this was after agreement as to a time and date, and he refused to allow. That would have been, I believe, the 5th visit with the child, because I believe I've met with him twice in my office and twice at the school.
And the female child as well.
Yeah, so
Valerie.
his complaint is to Ethan, but certainly I met with Valerie in each of those times, and I did conduct a home visit and meet with Valerie within the home with Miss Alvarez. But he did, Mr. Chavez did not allow that home visit and meeting with Ethan. So yes, Your Honor.
Ms. Hayes, do you have anything to add?
Your Honor, I'm familiar with that provision of the family code. And so I do not have any objection to the characterization of those fees as additional child support. My client has complied with the court's orders throughout for payments of those fees. And I would remind the court that the obligation to advocate in the best interest of the children applies to both children, whether or not Mr. Chavez continues to have a relationship with one of them. And so services rendered for Valerie's benefit would also be the obligation of Mr. Chavez.
All right. Any final words on that issue?
No, Your Honor. So is this hearing continuing, or is this the only hearing? Because if this is the only hearing, then I think I would need to call Mr. Chavez to be able to put on the record his side of the issues.
In view of the fact that you're going to seek withdrawal within the near future, I suppose, then I'll hear whatever evidence here on the matter and then consider any letter briefs and authorities and then decide it by submission. So if you do want to present evidence, let's go ahead and do it today.
Okay, understood. So then I would ask Ms. Carrion, do you have your invoices as evidence today?
I did not attach them to my motion, no.
Okay.
They can be submitted along with my letter brief if the court so desires to view them. But Mr. Chavez has viewed them. Ms. Alvarez has been given the opportunity to review them as well. And throughout the years, I think Mr. Chavez's big complaint when he reviewed those documents was that he did not believe that Ms. Alvarez had actually paid the portions that I noted on the statement that referenced her payment date and payment amount. His only objection was that he did not believe that Ms. Alvarez had actually paid those deposits towards my amicus fees. He did not question anything else other than he didn't believe that Ms. Alvarez had done her part.
Okay, and those invoices
You're
were.
referring to Ms. Melton? Are you referring to Ms. Melton? Okay.
Yes, her current name, Your Honor, is Ms. Alvarez.
Okay, I understand. All right. I'm sorry. Go ahead, Ms. Lane.
Thank you. Those invoices were provided in May of this year, is that correct?
You requested them and I provided them within a few days of your request. So I believe that was around the time of the mediation or around the time that you entered the case, because I brought that to your attention as a disputed issue and sought your assistance in resolving the issue.
And that was the,
would,
I'm sorry. Go ahead.
For which you affirmed that you would assist in getting this resolved.
And that was the first time that Mr. Chavez had been provided those invoices, is that correct?
Correct. They were all kept in the regular course of my work, but he had never requested them before and they had not been provided, but upon request, they were provided.
And he did pay $500, you acknowledge that, right?
Yes. For which then he consulted with me for a little over 2 hours right at the inception of the case.
Okay, I'll pass the witness at this time.
Anyone have any questions, Ms. Carrion?
I do not, Your Honor.
Okay. Ms. Lane, if you want to call another witness.
Yes, Your Honor, I'd call Mr. Chavez.
Yeah, he's under oath, so you may proceed.
Mr. Chavez, you have an objection to the amicus fees that have been provided to you in an invoice, is that correct?
Correct.
What is the basis of your objection?
All of her services that she had put on there There was a 2-year gap that she did not speak to Ethan or myself. So the payments that Ms. Alvarez was making was not my only objection. The other objection I had was we were going to have our final jury trial, and that's when the amicus finally decided to contact me to see if she can speak with Ethan. But prior to that, over 2 years, there was silence from her. The only thing that came from her was just billing. I never received a bill from her or anything like that.
Now, you heard the testimony that you had refused the amicus access to the child. Do you recall that?
I recall the conversation, but it wasn't a refusal.
What happened?
She wanted to meet, and I had said, well, you haven't spoken to Ethan for over 2 years, so why do you want to speak to him now? She hadn't done her duties as an amicus and has failed to do her duties. So I agreed, but then something came up and we were not able to be there, and I told her we weren't going to be there. She still showed up, constantly ringing the doorbell, because I have doorbell video, and harassing me, telling me that she wanted to speak to Ethan at the last minute, just because we were going to our final, and she decided to finally do her duties, which is a little too late.
Okay, just to help everyone understand, why did you not, reschedule and try to accommodate that?
There's not enough time. I mean, there's so much that happened within 2 years. Our scheduled final with the jury trial was I think a week away. So there was not enough time for her to catch up for those 2 years of everything that's happened in our case.
Were there any other times before that attempt was made? Were there prior attempts to contact your son by the amicus?
No,
When was the time before that you can recall?
I know it was over 2 years. That's when she last met with Ethan in middle school. He is now a sophomore in high school. So it's been over 2 years.
Okay, and it's your position that you objected to the appointment of an amicus from the beginning, is that correct?
That is correct.
And you've maintained that the amicus is not benefiting your children or their case, is that correct?
That is correct.
Is that the sole basis of your objection to the fees and their characterization?
I don't think my case is that difficult. I don't think an amicus is beneficial to the children or to the case. So, yeah.
And when you say that your case isn't that difficult, you're saying that, because of the situation where the children have been with each parent for such a long period of time. Is that what you're referring to?
That is correct.
Okay. Is there anything else that you would like to add and put on the record regarding this issue of the amicus fee amount and the characterization of the amount?
Well, as far as with the amicus did speak with the children in her office, and that's cool. According to Ms. Carrion, after that, I mean, she didn't speak to them at all. I don't know what the reason was, but she shouldn't have been put as the amicus, even though I objected to it since the beginning as pro se.
And to your knowledge, has Ms. Carrion been in contact with the children's providers, their doctors, their psychologists, counselors, any of that?
No. And that information has been provided to her.
Do you know the amount that's been requested that you pay Ms. Carrion today?
I believe it is around $6,621.68, according to our mediation offers.
And would that amount, if you were ordered to pay that as child support, create any type of hardship on your family?
Absolutely.
In what way?
Missing some bills. They're in summer right now, so after summer, I'm gonna have to continue providing for Ethan's high school. The higher the grade they go, the more expensive it gets for his schooling and his extracurricular activities.
What is he involved in?
He's in marching band. I'm not sure if any of you are familiar with, but it's very expensive.
Pay for things like uniforms, equipment, travel, things like that?
Correct. Yes, ma'am.
And for all of those expenses you have related to the child, is any child support ordered at this time?
No.
From Ms. Melton to you, if I could clarify that.
Correct.
And are you paying child support at this time?
They're still currently pulling child support out of my employment. Yes.
That's for both children.
Correct.
How long have they been pulling out? Has the Attorney General been pulling out the child support fees for both children? How long has that been happening?
That would be around 2019 timeframe. I'm not sure the exact date, because prior to 2019, we did have equal custody with no child support.
Okay, and how long have you had your son exclusively living with you?
Since December of 2022. So going into a little over 2.5 years.
Right, so for 2.5 years, Ms. Melton has been receiving the full child support. Well, let me rephrase that. For 2.5 years, you have been garnished from your wages for both children.
Correct.
And so this additional amicus fees as additional child support would further burden financially your family.
Absolutely.
And so what are you asking for regarding the amicus fees?
I think the $500 that was deposited at the very beginning is sufficient for the very minimal duties that the amicus has provided for this case.
I'll pass the witness, Your Honor.
May I respond, Your Honor?
Yes.
Your Honor, since 2022, I have been actively involved in this case. As much as Mr. Chavez wants to minimize that this was a very easy case, obviously the case has been pending for so long and there have been so many issues relating to protective orders, relating to the conflict, the habeas that have been filed, and the refusal to comply with the court orders as they were written. I have met with the children. I reviewed it at the inception, all of their medical records, and talked to their providers. Since time and since the order that the parties provide $500 on the first of each month thereafter, the intention was so that I could continue to do my work in my investigation. Mr. Chavez, since the inception, has refused to comply with that obligation. Argues that I don't do my work, but he also fails to recognize that his role in not complying with the court orders significantly impacts able to do it. There were 2 occasions
I'm
where
sorry, ma'am, could you repeat the end of that? It significantly impacts.
my ability to do the work that I am charged with doing. Thereafter, after meeting with both children 2 times at school and both children 2 times at my office, I've also talked with Ethan and Valerie at the court proceedings where they were brought and they testified in court. I've talked to them at those proceedings as well. I have received updates from Ms. Alvarez with regard to therapy and the starting and the stopping. I have been, the home visit was the one thing that was lacking, and neither party ever complained about an inappropriate home being provided by either parent. Both parents live in similar homes, similar amenities, completely appropriate from what I could tell from the outside of Mr. Chavez's home. Now, with regard to that home visit, Mr. Chavez said that the only time I could visit him was on a Friday afternoon at 6 p.m. I told him that is fine. I will be there at Friday at 6 p.m. He then, some hours later, said, no, it needs to be at 5 p.m. on that particular Friday. I said, fair enough. I will be there at 5 p.m. I reorganized my day to accommodate his requests. That was the end of the conversation. When I got to the home, I rang the doorbell. I saw shadows through, there's a cut glass in the window, in the front door, I'm sorry. And I saw some shadow and I wasn't sure if the doorbell was working. I rang the doorbell a second time. Then there was no response. I then attempted to call Mr. Chavez to inquire as to the reasons they were not there. There were cars in the driveway as well when I arrived. He would not answer my call. He would send it right to voicemail. I then emailed him and I inquired by email while still standing at the front door. I emailed through my phone to inquire with him about the conflict with time. And as everybody knows, that's rush hour traffic. That was challenging time to get there, but I accommodated his time frame. And he said, I'm going to refer you back to my prior email. And his prior email was complaining and objecting about, why do you need to see him now? The trial's coming up. Really, my intent was to verify that the home was an appropriate home, but that was not anything in dispute. And that's simply what he said. I refer you back to my prior email. So he never canceled. He never instructed me not to come. He just referred me back to a prior email. And the only prior email I could discern was where he wanted to know why now. I will tell you, the child exhibiting the most emotional response that I've been allowed to be a part of is Valerie. When I was appointed at the inception of this case, it was because Valerie was falling through the cracks. There was so much focus on Ethan, and Valerie's health and well-being was falling through the cracks. And that's why I was appointed by Judge Anderson back in 2022. My charge was to determine the best interest of both children. I have seen the change in Ethan, and I have witnessed the very disturbing nature in which he communicates with his mother and with which he communicates with his sister. And I have tried to assist them in finding a middle ground so that both children could continue to share a relationship together and have a reasonable relationship with both parents. I was I received Valerie's tears and fear with regard to the protective order. I was involved with trying to counsel her with regard to the protective order in terms of the role as an amicus, and as well as with Ms. Alvarez. Your Honor, this case has not been an easy case. And despite Mr. Chavez's, he then objected and motioned for my removal, which was denied. And so Mr. Chavez has been the party to continually create challenges above and beyond the normal custody dispute. As of April 15th, 2025, and that was prior to the mediation, the total invoicing on the case was $14,709.36, of which Mr. Chavez owed $6,849.68. Since then, and through the mediation, he has been provided a supplemental invoice for the billing that was for the time that was billed in May. And so the amount he owes is now in excess of that. And just for purposes of the court's understanding, Mr. Chavez makes significantly more money than Ms. Alvarez does. And despite that, and despite these being both of their only children, Mr. Chavez has refused month after month, year after year, to comply with Judge Rodriguez's order that he submit the $500 on a monthly basis. Had he done that as ordered, then it wouldn't be a hardship. Then there wouldn't be the conflict that we're dealing with now with a much larger obligation. But Mr. Chavez has refused. And I do believe that characterizing these fees as necessary for the benefit of both children is appropriate, and that the only way there will be compliance is through a withholding order for additional child support, Your Honor. I am unsure of whether the Attorney General's office is holding his child support contributions, but if they are, then I would ask that those be set aside to comply with the amicus fees. But the concern for the children, for both children, not just Ethan, has been substantial. This has been a very stressful case, a very adversarial case, a case where we've had to deal with things in the courtroom as well as outside the courtroom. And I ask this court to characterize the amicus fees as necessary for the children.
Ms. Lane, do you have anything else? Any questions of either Mr. Carrion or Mr. Chavez? Anything more? Or Ms. Melton, for that matter, if you want.
Well, just on the financial issue that was brought up by Ms. Carrion, I'm sorry, Judge, I think I do need to ask my client about that. Mr. Chavez,
Yes, ma'am.
is that a true statement that you make significantly more than Ms. Melton?
That is incorrect.
How much do you make a year?
I make 70,000.
What is your occupation?
I am a network engineer
With what company?
with Phileas Corporation.
All right, do you have any other children besides Ethan and Valerie?
No.
I pass the witness, Judge, and I'd like to call Ms. Melton after that.
Okay. Ms. Hayes, do you have any questions to ask either counsel or Mr. Chavez?
I do not.
All right. Go ahead. She's
Ms.
under.
Thank you, Your Honor. Is it Ms. Melton or Ms. Alvarez? I apologize.
It's Ms. Alvarez.
Ms. Alvarez, what is your current occupation?
I am a teacher,
At what school?
Jane Hambrick.
I'm sorry?
Jane A. Hambrick.
Is that a elementary, high school? What is that?
It's a K-8 combo school.
And what's your actual title?
Teacher.
Okay. Are you a teacher for special education or anything like that? Or which grades are you teaching?
Yes, I am servicing special ed students.
And what is your income?
67,000.
Do you have any other children besides Valerie and Ethan?
Myself, no.
I'll pass the witness, Your Honor.
Your Honor, just to satisfy Mr. Chavez's questions, Ms. Alvarez, you have had an opportunity to review the invoicing and the statements on the case, have you not, from my office?
Yes, ma'am.
And on the statement, it references each of your payments, the date that you made those payments. Is that correct?
Yes, ma'am.
And did you in fact make those payments, or are they falsified on that statement?
No, ma'am. I struggled, but I made those payments.
And Your Honor, I stand corrected on my comment that Mr. Chavez made significantly more. He makes a little bit more, and I want to correct the record with that misstatement. But thank you, Ms. Alvarez. I have no further questions.
Anything more on that issue?
Your Honor, if I might just advise the court, Mr. Chavez did partially comply with some discovery in the past. The information that I have regarding his employment, and that was the offer letter extended to him of January of 2022, is that his compensation at that time was going to be $75,000 annually. I don't know what it is presently, but I'm, I guess, a little puzzled how it would have gone backward.
You want a question on that?
Sure. Mr. Chavez, did you file a tax return in 2024?
I did.
What were your W-2 earnings for 2024?
I don't recall. I don't have it with me.
Okay. Would you agree with me, sir, that if you were initially offered $75,000 in 2022, January of 2022, 3 years later, you are most likely making more and not less?
That is incorrect, ma'am. We are under a government contract, so it changes.
Okay. So are you making less money now? With reminding you, Mr. Chavez, you are under oath and these numbers can be verified and will be verified.
From the last time that I checked, yes, it's less.
Okay. How is it that you check? You have a pay stub that you can access, Mr. Chavez, for the judge?
No, I don't. Not here.
Okay. Your Honor, I would simply ask that Mr. Chavez furnish that in addition to the briefing. I think that would assist the court in making its decision.
Okay.
Additionally, Your Honor, I'd ask that he'd submit his tax return as well.
Okay, in determining my decision in this regard, then I will require a brief briefing. I don't want any multi-page. I just need the authorities that you need to cite that supports your position. You know, the disparity of income, I don't know how it's relevant toward making a decision towards characterizing the, is it necessary, the amicus fees as necessary, characterizing them to where withholding is in order. I'm not gonna, you know, really, I don't see it. It's really mainly a legal question. Mr. Chavez, I can tell you right now, it's undisputed that there was a court order naming Ms. Carrion as the amicus under the law, period. You disagree, fair enough. But that order is in effect. So now the only issue is not whether you owe something, you do, is the issue of characterization of that as being necessary. And that's why I'm asking the attorneys to brief that and provide me case law in addition. So the issue of whether it's owed is not, that's a done deal. There was a court order, certain amount, it's either was paid or it wasn't paid. I'm not going to review what Ms. Carrion did or did not do. We're not going to argue that because it's not, it was ordered. Regardless whether you agree with it or not, whether you agree whether she did her job or not, that's not going to be an issue. So just a word to the wise, that's a done. I mean, that was a court order. She ordered it in a certain amount. It wasn't paid. Or if you think you paid it, then prove that. It's just the law, whether I can characterize it as necessary and as a result, order the withholding. So that's really the only thing I'm going to have to brief on. All right.
Just Your Honor.
And I assume nobody mentioned it, but I assume that since, and maybe you did, but I didn't catch it. Any child support in the future, there's not going to be any because one has custody of one child and one the other. Is that correct?
That was something we were not able to agree on in mediation. We had wanted that.
I'm pointing that out right now. So, so there's no agreement as to that.
No, Your Honor.
And
So-
medical support as well, Your Honor. There's no agreement on.
On medical support.
Right. So child support and medical support in the future were not agreed.
Okay, so what are the positions of the parties? I'm not going to decide that today, but for a future time, but what is the position of the parties?
Position is that they each should not pay child support to each other, that it should immediately be suspended, and they each be responsible for the child that they have sole managing conservatorship of, including the medical expenses for that child. That was our position.
That's Mr. Chavez's position. Okay.
Yes,
And
Your Honor.
Ms. Hayes?
And Your Honor, my client believes that guideline child support should be calculated and offset for each child, pending verification of current earnings. And so what her guideline child support for Ethan should be considered, as should Mr. Chavez's guideline child support for Valerie. And the higher wage earner should pay the difference to the lower wage earner. So there would be some offset, mathematical offset involved there. And that Mr. Chavez should provide health and dental insurance for both children through his employer.
Okay, thank you. And
And
we need to set a live hearing for that?
We will, Your Honor. Yes.
just so I can put on the record, because, you know, Mr. Chavez was asked about his tax returns and his pay stubs, and Ms. Alvarez was not asked that, but my understanding is that she does have 2 other jobs as well that
Well,
she earns income from.
yeah, that's gonna be important toward the issues of whether there be child support or none of each.
Understood, Your Honor.
But as far as the characterization issue, I'm not gonna require it.
Understood.
So. But certainly for that hearing that we have on the child support, the parties are ordered to produce every bit of income information that they have. Both parties are for that. All right. Okay.
For that
So-
briefing, may I have a deadline of when, would you like it by Monday, Tuesday, or by next Friday, the 20th?
By Friday.
By Friday, the 20th.
By Friday. Yeah.
And that'll be from both of us. Our deadline is,
Yes.
thank you.
Okay. And so that's that out of the way. Miss Elaine is gonna prepare an interlocutory order to distribute, and submission date is the next Friday. We need to go ahead and set a hearing on the issue of child support. So let's go ahead and do that. How long, throw me some dates. Can y'all confer and agree and then get with me on my availability? Shall we set a date right now and just? however you
think-
want to do it? I don't want to get any resets. I detest resets.
I
I
understand,
get
Your
those things,
Honor.
I gotta pull my calendar out, I gotta look, so if you can give me dates right now in the reasonable foreseeable future here, then we can go ahead and set it right now. So
Yes.
look at your calendars if you would, and kind of let me know. Now the issue there, Miss Lane, of course, you may or may not be involved in this. I don't know when you're going to file that. I don't know whether you want to discuss with Mr. Chavez privately on your own continued representation in regard to that issue, the child support issue. I don't know. That's up to you and him. But there's that possibility. So I don't know. I just don't have that motion to withdraw, so I can't even. You told me you were going to file it eventually, but
Yes, Your Honor. If we could maybe set the hearing in July, so I have time to do whatever it is that we end up doing,
yeah.
if I withdraw or
All right.
stay on.
The week of July 14th in the afternoons look open for me.
I am in a jury trial the week of the 14th.
What about the 22nd?
I'm in an all-day mediation.
Yeah, and I have a doctor's appointment that I need to make in the morning, but
The morning of the 23rd?
we have jury trials scheduled that week, right, Jacqueline?
We do, Judge.
They're just a bunch of them. They may or may not go, but they're set. So
I'm looking for a half day, Judge, assuming that that's the minimum amount of time that it would
yeah,
take.
I don't think it'd take more than that. How about the week of the 28th? What do we have there, Jacqueline?
I'm out of town the week of the 28th, Your Honor,
Okay.
through the 4th.
What about July 25th?
Yeah, July 25th. I'm likely to be finishing the jury trial by then.
I could do the morning of July 25th.
Miss Lane?
Yes, that works for me. Does that work for you, Mr. Chavez? July 25th in the morning?
Yes, it does.
I'm available as well.
Would this be in person or in Zoom?
I think I'd prefer it to be in person.
In person. Okay.
Ms. Carrion, how does it look for you?
It's available. I'm available. Yes, Your Honor.
Okay.
And just to clarify, Judge, would this just be for the child support issue or all remaining issues?
Well,
Uh,
there's the issue regarding the amicus fees, that I heard the evidence today. I'm going to receive briefs, so I think I can handle that by here on out by submission. I'll prepare a letter judgment decision and send it to you for preparation to include it, I guess, in the final order. So just the child support matter.
and then I think the only remaining issue would then be attorney's fees. Is that right,
And-
Ms. Hayes? I think that's the only remaining issue.
And attorney's fees. Yeah. Is that so? Child support and attorney's fees on July 25th at 9 a.m. Unless you're advised otherwise, he'll be on the 9th floor.
It'll be on the 9th floor.
Court. Okay.
And it'll be set through 9 to noon?
Yes. All right. Anything else?
No, Your
No,
Honor.
No, Your Honor.
All right. Well, have a good rest of your day, everyone.
Thank
Have
you.
a good weekend.
Actually, I'm so sorry. I think there is one last thing. So since the child support hearing has been set to 7:25, will Ms. Alvarez have a deadline to provide her financial information, the same as Mr. Chavez?
Did we have a deadline for him? I don't know if we had a deadline just before, but it's a good idea to set one.
I think you had said you wanted him to provide it with the brief on the 20th.
He
Or
said that
maybe not. Maybe I understood.
Because I mentioned that wasn't relevant for the issue of characterizing it.
Right.
So, if you could have it to each other by the 21st, that way you can look at it. Perhaps you can reach agreement. I don't know, but nevertheless, by the 21st, say, of July.
Yes.
Before the end of the day.
Yes, Your Honor. I'll generate an order for that issue.
Okay.
Great.
And
And then I really don't have anything else. Sorry about that, Judge.
no problem. No problem. It's good to clarify it. And yeah, we need a deadline for the financial information for that particular hearing. That's true.
Yes.
All
Understood.
right. What else? All right. Have a good day. We're adjourned.
Thank you, Your Honor.
You too.
Thank you.
bye.
Judge, I'm gonna let the other parties in for the other case. The 9 a.m. one.
So what other case?
The final hearing.
Okay.
And I let them know that we were late.
All right. All right. Good morning. Sorry, but had a case that went over quite a bit. We're hearing cause number 2012 DCM 07399. In regard to the child, I guess, Edwin Mayorga.
Judge, we're just waiting for the court reporter.
Oh, you know,
No, I'm here. Thank you.
she's been there. All right. If I can hear announcements, please.
Christina Montes on behalf of Kayla Adamson, Your Honor, ready to proceed.
Good morning, Your Honor. Joy Degenhardt on behalf of Edwin Myrica, and we are ready to proceed. And Your Honor,
Okay.
the parties have reached an agreement on all issues. We actually just have an agreement to put on the record, but we have reached an agreement.
That
All
is
right.
correct, Your Honor.
Okay. Both parties, please. Mr. Mayorga and Ms. Adamson, would you raise your right hand to be sworn, please? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God, Mr. Mayorga?
I do.
And Ms. Adamson?
I do.
Very well. All right. Who wants to go? Who's the petitioner?
Your Honor, thank you.
Okay, Ms. Degenhardt, if you could just speak up a little bit, you kind of got a little echo going. It's not too bad, but just to make sure you speak up.
Okay. Your Honor, the parties have agreed that for the conservatorship rights, that Ms. Adamson will have independent rights to make medical and psychological decisions for the child. There won't be any other changes to the previous conservatorship rights and duties. Your Honor, for the possession and access, the parties have agreed that the parent who, in a given year, the parent who does not have Thanksgiving in that calendar year will have the fall intercession, and the other parent in that same in the following year will have the spring intercession. And so the goal of the parties is to reduce the travel back and forth and also try to equalize the time with the child. Your Honor, for the child support, Ms. Adamson's support obligation will increase to $400 a month beginning July 1st, 2025. For long distance travel provisions, Ms. Adamson will be permitted to purchase flights for the child that include an equipment change or a layover for the spring, summer, and fall visits. But specifically for Thanksgiving and Christmas, she will be allowed to purchase flights with a layover, but the child Eli, his brother, will accompany him for at least one of the connecting flights. And the layover will occur in the city where the brother is either joining in or leaving the flight. It's the intention of the parties that Eli not have a layover for Thanksgiving or Christmas in a city where there's no support in the event that there was weather causing a delay in one of those flights. Your Honor, for the electronic communication, the parent not in possession of the child at a minimum should have electronic communication Monday, Wednesday, and Friday at 5 o'clock Mountain Standard Time. If a call is missed, then the parent in possession will ensure that the call is returned. And then, Your Honor, everyone is paying their own attorney's fees in this case.
All right. Ms. Montes, anything to add to that agreement?
No, Judge, that is absolutely correct, and that is our understanding of the agreement as well.
Mr. Mayorga, you heard Ms. Degenhardt go through the terms of the agreement. Is that your agreement?
That is correct. That is my agreement, Your Honor.
All right. Do you feel it's in the best interest of the child?
I do. I do.
All right. And Ms. Adamson, same question to you. Is that the agreement that you heard from the attorney?
Yes, Your Honor, that is.
And do you feel that's in the best interest of the child?
Yes, I do, Your Honor.
All right. Then that agreement will be is the judgment of the court, and the only thing left to do is to prepare the judgment. And who will do that?
I will be preparing the order, Judge, and I do anticipate to have it here within the next week.
All right. just I'll give you until, what? Maybe I'll set a deadline for the 27th,
That would be perfect, Judge. I appreciate that. Thank you.
June 27th, will be the submission hearing date. Actually, it won't be hearing, it'll be by submission only. That means that's the kind of the deadline, okay, at 4 p.m.
Understood, Judge. Thank you.
Okay, anything else?
Nothing further from us, Your Honor. Thank you.
Nothing
All
further
right.
from us. Thank you.
Everyone have a good weekend.
Thank you, Ms. Degenhart.
Thank you. Thank you.
Bye-bye.
Thank you, Jackie. I was trying to eat M&Ms.
I'm sorry, I missed
No,
your
it's okay.
break. I didn't ask you. I'm sorry.
No, it was fast. Okay, thank you. Have a good weekend.
Erica,
Bye.
be good.
You too.
We'll see you in the afternoon, Judge. Thank you.
Okay, I think I got out of. Yeah, I'll see you this afternoon then.
Okay, thank you.
Okay, bye.
Bye.
Bye.